It is remarkable how many people plead guilty, 97%. Why do so many people plead guilty? Well, obviously, a number of people, the lion's share of people who plead guilty, are guilty. That doesn't change that the trial penalty, the trial tax that we're going to cover in this video or podcast, the trial penalty plays a large role in influencing people who may have won at trial, who were innocent. Believe me, innocent people have pled guilty to federal charges and have served time in prison. Not all. I don't buy into that cliche that everyone who is in prison says they're innocent. Not true. I was in prison. The majority of people, the lion's share of people, did not say they were innocent. Just good old movie type stuff. So in this video, or if you're watching on YouTube, or if you're listening to this podcast while driving, thank you. We're going to cover the trial penalty and the reality that accompanies getting embroiled in a government investigation and how difficult it really is to emerge as unscathed as possible. And that's really the goal for any defendant. Once you're immersed in this system, once you're in the crosshairs, what can you do to get out? And of course, part of the reason some people who are innocent plead is because it can help them get a more favorable sentence. So I'm going to engage in a little bit of high technology screen sharing here. For you podcast listeners, I encourage you to go to the Prison Professor's blog. You can read this article on the trial penalty. While there, subscribe. You'll become a part of our weekly newsletter. It's free, and we're going to deliver you a lot of value, which is what we always try to do. And if you're here on YouTube, go ahead and subscribe as well. So the trial penalty, the definition, incentivizes all defendants to plead guilty. Why? Well, it's pretty obvious, right? Defendants may face a significantly harsher sentence if convicted at trial. I filmed a video earlier today discussing whistleblowers and how that process can unfold, and shared a story of a client who believed himself to be innocent, turned down a deal that got him probation, convicted at trial, got several years in prison. He's one of the few people that would say, I'll spend the rest of my life in prison before I say I do anything wrong. It takes a lot of commitment. It takes a lot of fortitude to do that when you could accept probation and instead you go to trial, you get several years. I suspect in this article, we're going to cover something similar, right? Where someone can get a shorter sentence. Instead, they go to trial and get punished by the government. There is a very rare criminal trial taking place right now in this country. And of course, that's the Elizabeth Holmes trial. It's getting underway. And she is enduring, if she loses, the trial penalty. Now, some people are adamant about going to trial, very, very rare. But if she loses, the penalty will be significantly harsher than had she pled guilty. The National Association of Criminal Defense Lawyers, great group, says a person convicted after choosing to have criminal charges adjudicated by a jury ends up with a harsher prison sentence than a guilty plea. Makes sense. But how could that be when the Sixth Amendment of the U.S. Constitution guarantees a criminal defendant the right to a jury trial? As we wrote in this blog, you can get at Prison Professors along with other resources. For most criminal defendants, exercising the right to a jury trial can have negative practical consequences. Indeed, there are so few trials today. To put that in perspective, our team at Prison Professors and White Collar Advice, we've personally guided more than 1,000 clients since 2009. We estimate 30 to 50 of those, give or take, have gone to trial. Not one has prevailed. Now, our team doesn't bear responsibility for that because we're not the trial lawyer. We can still mitigate and help them prepare for a shorter sentence. But I can assure you, now some of them have prevailed on an appeal, okay? But do you think of those 30 or 50, some of them were innocent? Of course. Of course. I know these are our friends. We work with them. We know them. Some have said I would have done things differently. Maybe there should have been a civil investigation. Some have outright said, I didn't do anything wrong, and I'm not taking probation or a year in jail. I'll serve 10 years in jail. I didn't do anything wrong. So the odds of prevailing are just so incredibly low. Therefore, the trial penalty absolutely incentivizes all defendants to plead guilty, and it keeps the engine of the American criminal justice system humming at top speed. So these prosecutors, when they go into private practice someday or join the big white-collar crime firms, leverage off their conviction rate. I don't think that is that impressive, considering 97% of people plead guilty. 97%. That is a massive and huge number. It comes to what I said a few moments ago. Once you're in the crosshairs, very difficult to get out. Some people just say, I got to get out as as best as possible. The trial penalty is the significant disparity between the prison sentence offered as part of a plea bargain and the longer sentence imposed if a person gets convicted at trial. Some people believe that, well, I'm going to get the same sentence whether I go to trial or plead guilty, or if I take a deal, I'm going to get a year and a day. And if I lose at trial, I'm going to get 2.5 years. So it's worth it to take the deal, like not to take the deal because the sentence isn't that much longer and there's a chance I could get off, or there's prosecutorial misconduct. Part of the trial penalty, the trial tax, they make the chasm or gap so wide to try to make that clear. That ain't going to happen. You can take a deal and get a year and a day. If you lose, you're getting 5 years. So, and there are people, going back to my time in prison, I used to walk the track with a gentleman who used to say to me, you know what, dude, 15 years ain't 5. At the time, he couldn't imagine doing 5 years in prison, which was the plea agreement offered to him. So he's like, I might as well roll the dice and try to win, because I can't do 5 years. And if I lose, I'm going to get 20. So what's the difference? He ended up losing trial. He got 15. And as he said to me in a blog our team wrote so long ago, he said, you know what, dude, 5 years ain't 15. I'd have been home a long, long time ago if I took the deal. So the gap is going to be significant. And I want you to understand that. When I hear, a year and a day and 30 months, show me the data. Show me the case studies where that actually happens. It doesn't. The NACDL investigates sentences and other data to determine why less than 3% of cases proceed to trial. Again, 97% of cases settle through a plea bargain. NACDL efforts hopes to increase awareness of the trial penalty across federal and state systems. They want to keep sounding the alarm about defendants having the right to a jury trial. And basically, they write that defendants are under siege. They really have no choice but to plead guilty because the trial penalty or tax is so significant. The prosecutors are not preparing for enough trials. And when they do happen, too few innocent defendants are prevailing. It is so difficult to have a jury of your peers view you objectively. I think some people presume it's United States of America versus your name. Right out of the gate, you're in the hole. It's like, I believe, going to the ninth inning, bottom of the ninth inning, you're down 5-0, and you have the Cy Young Award winner on the mound. You ain't going to win, not that often. Why is there a trial penalty? Among those who actually recognize the trial penalty, there are a number of reasons. Former federal judge John Gleeson outlined 3 significant issues in his NACDL report from 2018. 1, the growth of mandatory minimum sentencing laws. These one-size-fit-all penalties, he writes, enables prosecutors to coerce guilty pleas and severely punish anyone who opts for trial. So in a mandatory minimum, for a drug case, for example, it could be a 5-year mandatory minimum, or identity theft in the white-collar world, or any crime for that matter. And identity theft can be 2 years mandatory minimum. Well, they'll say, if you take the plea agreement, we'll ask for the 2 years. But if you lose, we're going to add on other charges, supersede the indictment, get 5 or 10 years. You're going to begin to see that in the Varsity Blues case, where a lot of defendants pled out early, 2 months, 5 months in prison, 3 months in prison, 14 days. A jury trial just started for 2 parents in the Varsity Blues case. If they're convicted, they ain't going to be getting 3 or 5 months in jail, I can tell you that much, even if their conduct is the same. That will be a great example if Judge Gorton, if they're convicted, and if Judge Gorton sentences them to prison, which he will, to see the disparity or gap that followed between pleading guilty for a parent and actually going to trial. I suspect will be the first sentence in that case, presuming before Rick Singer sentence, that will be more than a year. To date, I don't believe anyone's gotten sentenced to more than 9 months, and I believe it was Doug Hodge, the executive from PIMCO. Second, harsh sentencing guidelines. Federal and state guidelines establish draconian punishment ranges that, like mandatory minimums, pressure individuals into pleading guilty. Again, take a plea, you're going to get a year and a day. You go to trial, we're going to ask for 7 years. Hardly a choice. Go along judges. Too many judges, according to Judge Gleeson, simply go along with the prosecutor's sentencing recommendations. As such, judges inflict harsh penalties when defendants demand and lose their right to a trial instead of imposing a significant proportionate to guilt. Another reason so many defendants plead guilty is the resources that it takes to go to trial. Sure, you can have a federal public defender appointed to you, but to go up against the U.S. government that has endless resources, it's just so incredibly difficult to prevail. And even if you were to win, some people in the interim go broke and lose every penny they had if they do win, which so few people actually do. Advocates, coming to specific examples of the trial penalty or tax, claim the trial penalty violates the U.S. Constitution and they identify some cases. For example, some defendants who decline to plea a bargain are guilty after trial can receive sentences that are 10 times as severe as prosecutors offered during the plea negotiations. Specifically, there was an article in the Wall Street Journal where a doctor was offered 1 year if he pleaded guilty to Medicare fraud. Instead, after his conviction at trial, he was sentenced to 11 years in prison. His doctor said the doctor rejected the plea offer because he believed he was innocent and he had expert testimony at the trial to back him up. In another case, 2 businessmen accused of financial fraud declined offers of 7 years in prison, but their sentences were a staggering 80 years after the trial. Wow, 7 to 80 years. I mean, 7 years in the federal system with good time, halfway house, first step back, potentially RDAP, a compassionate release due to COVID. You could be out of there in 2 or 3 years. It ain't 80 years, which is essentially a life sentence. Another justification for the disparity is that defendants who plead guilty deserve less time because they've taken remorse and they've accepted responsibility. Understandable. But some, again, will debate it. Defendants can appreciate the reasons for accepting a plea deal without feeling any guilt or remorse in doing so. Indeed, among many other rational reasons criminal defendants to accept a plea bargain offer significantly lower, prosecutors agree to drop or reduce charges, and legal cost savings. Recently, our team worked with a husband and wife who were indicted, and the husband was adamant that he was going to be going to trial. And the government, I think, was apoplectic that he was going to go to trial. And like going through discovery, he had a lot of resources. And then they determined, that his wife worked for his company for a little while. And they didn't just threaten, they indicted the wife. Well, what's the first thing that he did? So, well, I got to keep my wife out of prison. So he took a plea agreement, no trial. She got probation. He got prison. Until this day, he said, the only reason I did it was because they threatened to throw my wife in prison. And I would argue a gross form of prosecutorial misconduct is the threatening to overcharge or actually charging people who shouldn't be charged, which could then compel a defendant going to trial to plead guilty. Hard to prove. It certainly exists. Hard to punish, hard to catch, but it's sickening and it absolutely exists. Prosecutors can reward defendants who waive their trial rights or provide helpful information to the government without seeking excessive sentences for people who choose a jury trial. That's another ironic twist. You can have someone who's the most culpable, the orchestrator of a fraud, plead guilty, cooperate. People who are less culpable can go to trial, lose. The person who went to trial who's less culpable gets a longer sentence than the organizer who cooperated. Really, really warped system. That's why it's essential that everyone learn everything they can about government investigations, go to Prison Professors, read our articles, download our free books, join our newsletter. It's imperative that you prepare. One case, as we begin to wrap up or make our descent to the end of this video, we feature Joel Eskenazi receive one of the harshest sentences ever. His co-defendant, Carlos Rodriguez, received 7 years, which was a pretty long sentence. In his case, he received a significantly longer sentence because, again, he chose to go to trial, the trial penalty, right in front of him. Most defendants, again, quickly plead guilty and cooperate with the Department of Justice. Eskenazi exercised his right to a constitutional jury trial. He lost. Putting the government to the task is a no-no, according to them. They don't like it. Multiple defendants in a massive bribery scheme involving more than $100 million, Nigerian foreign officials, received an average sentence of just 2 years. They pled guilty and cooperated with the DOJ. The convictions of Eskenazi and Rodriguez involved payments of $890,000 for bribes. A lot of money, but not what you would expect in a lot of these massive and huge cases. Experts comparing these cases point out that Eskenazi's conduct related to the Haitian officials paled in comparison to the Nigerian's $100 million bribery case. Still, Eskenazi and Rodriguez received a significantly harsher sentence only without question, because they went to trial. To conclude, the trial penalty incentivizes all defendants to plead guilty because they're going to get a shorter prison term than if they went to trial. We don't think it should be the case. While the criminal justice system is right to reward defendants who accept responsibility early, plead guilty, and cooperate, it shouldn't do so at the expense of others who rely on the Sixth Amendment rights. In practice, the trial penalty absolutely discourages or dissuades defendants from exercising their right to a trial by jury. When deciding whether to plead guilty or go to trial, speak with a lawyer, speak openly, speak honestly. I will tell you, some of our clients over the years who went to trial and lost, and they served time in prison, may come home and say, I don't regret going to trial, but time immemorial, I've come to see my case differently. I can sort of understand the government's version of events while I don't agree with it. And now I can really see how the government convicted me or the jury convicted me. You see it differently when you're in the heat of the moment, and time in memorial or time in reflection allows you to reflect on what you would have done differently. And indeed, some clients who went to trial and lost in retrospect say, probably should have taken that deal. Others say, I'd spend the rest of my life in jail before I ever pled guilty. Fortunately, none of them got life sentences for insider trading or other white collar crimes. Fortunately. Thank you so much for watching this video and listening to this podcast on the trial penalty. We're incredibly grateful. You continue to return to Prison Professors on YouTube or on our podcast to get educated and informed on how to prepare and overcome a government investigation. Thank you so much for your time, and we look forward to returning soon with more valuable content. Bye-bye.